about to have a breakthrough in AIDS medicine or something like that, then maybe the dividing line, the Lakshman Rekha, would shift. It would be case by case, fact by fact.
Because particularly in this relaxing case, the issue involved was you cannot make a pregnant female.
Supposing she consents, supposing the consent is for money terms, then where do you draw the line? These are all, I'm not saying, these don't really permit of an answer, but yes, this is very important.
This is like a surrogate mother. You see, the law is yet to develop. But then it may involve a moral issue, may not be a legal issue properly. So therefore, these are matters which are evolving. And you see, law will take its own course. The matters of interpretation and a matter of perception of a particular gentleman. We have, I'm just now told by the organizers that there is another speaker. But I would request her to finish within 5 minutes so that we can continue with this question answer session. So Dr. Vinay Kapoor, she is Associate Professor of Guru Nanak Dev University. So please complete whatever you want to say within about 5 minutes time.
Good afternoon, everybody. I will not be far between the lunch and you, but I would like to point out the question she has just asked about the traditional knowledge. Just imagine the situation that for a pinch of turmeric, if we have to pay lots of dollars or pounds, or for neem, what would happen? Thanks to one of the institutions, Council of Scientific Research of India, who timely challenged the patent asked by the American company for the medicinal value of the turmeric and neem. But there are many other things which are being taken away from the indigenous people, which is in the form of the traditional knowledge, and they are being cheated, they are not being compensated. The thing is, what is traditional knowledge? We don't have any specific definition, but any information which we are collecting in an informal way from generation to generation. So we may not have any systematic record of that, but we know that knowledge is a knowledge, whether it's in the form of formal or informal. So think about those tribal people who know all the medicinal value of the various herbs, and they also know the behavior of the animals. I remember when tsunami came, the people were fearing that most of the species must have undergone or they have been washed away by the tsunami from the Andaman and Nicobar Islands. But thanks to the traditional knowledge of those people, and they saved their lives, which could not be saved by the latest equipments of the science. And many lives were lost. We could not have the prior idea of that tsunami. So many such knowledge is still in the hands of those indigenous people or the tribal areas. But the thing is, they are not aware about those knowledge, that how they can get the patent right for those things. Multinational companies came, they take away their experience and they just tap it and get the patent for that. Even if they knew about that, the registration fee for the patent is very high. That's why the cases of patents in India is very small as compared to the developed countries. So, to me, the whole patent law is a sort of terrorism. It's another form of terrorism by the developed country against the developing and underdeveloping countries. This whole patent law needs to be changed. And sorry to say that there is no legislation regarding this to protect the traditional knowledge. We have the international initiatives starting from the 1994. Then we have certain provision in the TRIPS Act, but still the member states have not legislated any law, including India. So there are if you can have my paper, yes. I will provide it.
We would like to have your paper, please. Now, you are right, ma'am, that you say so-called indigenous goods are concerned, they have to be protected. For example, neem, tulsi, haldi, all have become patented outside and not in India. That's the unfortunate part, and we have to also now fight so-called basmati is concerned. Although it is our rice, but we are fighting against patent of basmati outside. Anyway, these are matters which need consideration, and I believe we have had a very fruitful and very meaningful discussion, effective discussion. You have some question?
One question.
Yes.
In the US also we had natives, the American Indians, and the settlers. And the patent laws have essentially developed in the US in relation to the technologies. And we consider it to be reasonably well developed there vis-a-vis the rest of the world. So what happened, what was the experience in America where the native American Indians must have felt challenged regarding the technical, the traditional knowledge which they had? Was there any such instance in the US?
You're asking me that?
Yes, it is directed to you. US law.
Well, I don't think our patent laws go back that far. You know, because when the American Indians were here, when the British and other Europeans settled there was no patent law, and you know, whatever they had was just up for grabs. So as I said earlier, I'm not really an expert in this field, but I'm pretty sure that's correct. That there's not there wasn't.
There's
any
no
protection for them.
There's no known experience of any case or heard of any such instance where the Native American got challenged and went to the courts or any such thing like that.
Well, not that I'm aware of. There might be some. There might be one, but I don't know. Simply because
the area of traditional medicine. I think every old civilization has traditional medicines which are very effective. And in fact, probably better than the modern medicines at times. And I think most of us have experienced in our own houses. In India, at least, in every house, there is a sense of traditional medicine already ongoing. And I think in older older civilizations, all over the world, it must be existing. And it is pretty effective. It's a question of sifting the non-effective from the effective and then trying to protect it for better use rather than having it patented and monopolized by one individual monolith.
Right.
I think that is the problem that we face.
See, so far indigenous medicines are concerned, this is used at every home. You don't have to have patent for that. But if you want to market it, then only a question of patenting will come in. So therefore there is some difference between the one that you are asked.
There are some excellent tribal medicines.
In
fact, I have done some research over it. Several tribal medicines are there, which are really excellent. And we are not having sufficient knowledge, unfortunately.
All right, now, so therefore, with this, we come to the end of this. There will be vote of thanks now. Yes.
I hope you have a very knowledgeable session and a fruitful discussion. I formally thank Justice N.P. Sharma for chairing this session, and Justice A.K. Ganguly, Justice P.S. Narayana, Mr. C. Donald Johnson, Mr. Raj Tripathi, and Mr. Robin Jacob for their papers. And I invite all of you for a lunch session after this meeting. Thank you, everyone. Thank you.
You have the paper?
threats that we face. What I'll do is maybe speak for a few minutes to set the context of what we are discussing, and then I'll introduce both of my speakers to you, very eminently qualified individuals to speak on this panel. But after that, I'd like it to be more of an interactive session. You are very learned people here in the audience, and I think the real value of a discussion comes out when we do it more interactively. So that's sort of the plan that I'll follow here. We still have a good bit of people coming in. Let's give them a time. Sit down.
You might be disturbed with the
All right. Well, see, this is both cognitively and in legal terms a very challenging subject. We are talking about framing in technical and in procedural terms what threats are that face countries, both domestically and internationally. And then you're looking at the supervening structure of law. When countries become parts of treaties, it enjoins upon them a set of binding obligations that they take on. So one is that aspect of the discussion that we have, the national to the international. The other part of it is looking at the capacity that a state itself creates within itself to be able to carry out the mandate, the legal mandate that it brings from the regimes. So that is the other part of it. And of course, all of this is being done in the context of what are the threats that a state faces. By way of introduction, as we still have people coming in, let me just make a few remarks. You all know, especially in an audience like this, that international treaties carry the force of international law. Examples in this field that we are discussing are the Nuclear Non-Proliferation Treaty, which India is not a party to, by the way, and the Chemical Weapons Convention, which India is a party to. CWC is also unique in that it is the only disarmament-based, time-bound disarmament-based treaty to destroy and eliminate a whole class of weapons. And India is actually the first country to have met ahead of its schedule, its destruction of its existing chemical weapons stockpile. So you have a class of bodies that we deal with, which are the international treaties. I mentioned them in the nuclear and in the chemical sector. You don't have one on the missile or missile, as we call it. Right? What you do have are international regimes. These are informal collection of individual states. The ones that we will be discussing briefly would be the Nuclear Suppliers Group on the nuclear side, the Missile Technology Control Regime on the missile side. On the chemical and some biological items, you have another group called the Australia Group, and yet another group which deals with conventional weapons and some missile-related aerospace items, which is called the Wassenaar Arrangement. And these are examples of international regimes that have membership of approximately 32 to 45, 46 countries. These regimes get their effectiveness not from the fact that they are anchored in international law, but the fact that the member countries decide to take these guidelines and adopt them into their own national laws. And so it carries the force of national law behind it. And the extent to which these countries are able to coordinate their guidelines and their behavior amongst themselves, the regime is very effective. It presents two challenges for us in India. One is, India is not a member of any of these regimes, and so is often on the I need to get this right. Anyway, I was saying that India is not a party to these treaties, and that affects the level of technology and